Today, I am with pregnant and pop partner Lucy, who is the managing director of Pheonix Wills here in Singapore. If you have ever wondered what will happen to your children if your partner and you pass on, do you know if they will go into state care? Do you know if you need a will? And if you've lived in more than one country, how do you or your estate manage your affairs in all the different countries that you have lived in? If you've wondered those things, then this masterclass is for you. Our topic today is Guardianship and Wills. How can I best protect my children? In this masterclass, Lucy will help us to understand the importance of setting up wills, guardianship, and other estate planning tools so that your children and your loved ones are properly protected. The legal stuff. The educational content of our masterclasses is the work of our pregnant and popped partners. We are not licensed medical or legal professionals, and this is neither a medical nor legal platform. The content of today should not be considered medical or legal advice in the truest sense. Instead, it is always best to consult with your specialists, Lucy is one, for any specific concerns or questions, and use the information from today as a complementary tool to help guide those discussions and care plans. In short, our goal is to provide a supportive and informative community for expecting and new parents, but it's important to always prioritise your own health and the advice of your specialist providers. Now, if I can just take a moment to very briefly introduce myself before we get on to the juicy stuff. I'm Cathy Rougier, the founder of Empower and Pregnant and Popped. At my core, I am a certified postpartum doula, which means that I provide home-based physical and emotional support in the first few days, weeks, and months of having a baby. I visit people's homes for either 2 or 4 hours each consultation, and I provide hands-on support for all things postpartum recovery and newborn care. I am with you in the trenches, wiping your baby's bottom at the same time as mopping your brow, with different tissues, of course. But this masterclass isn't about me. It is about helping you prepare for the future. So let me introduce our guest. Lucy is originally from the UK, a Brit like myself, but home now is very much in Asia. She has spent over 7 years between Hong Kong and Singapore. She is a lawyer with over 10 years of experience in private practice and in-house. And although she's not practicing here, she is able to put that incredible knowledge and skill set behind every bespoke will and guardianship arrangement that she assists families with. Alongside Pheonix Wills, Lucy's 2 young children keep her busy and are no doubt the inspiration behind having such a knack for helping families with young children navigate this subject. I've genuinely heard Lucy often express that the best part of her job is being a huge part of the sigh of relief when her clients sign their documents, ticking off an all-important life admin task that for many of us, me included, had been sitting on the to-do list for some time. She enjoys helping out with something that can seem daunting and stressful and taking that load off clients' plates. So without further ado, I am going to hand over to Lucy.
Thank you, Cathy. And thank you everyone for joining today. Happy Monday. I was saying to Cathy earlier, this is quite a quite a Monday topic. But no, the first thing I want to say is I'm really aware that this topic is one of the heavier ones, but it's just so important. I'm sure, sadly, all of us have directly or indirectly been in touch with a situation where people haven't set up their wills or haven't set them up properly, and the mess that causes. So here we are on a mission to try and spread information as far and wide as possible about why it's important, what we can do to protect ourselves and what we can do to protect those we leave behind. I'm going to put your minds at rest. I'm not going to talk at you for an hour. Cathy has set some time aside at the end for some Q&A. So please feel free to ask any questions. Also, if any questions feel a little bit personal, I totally understand that. Please feel free to get in touch with me separately. I'm really happy to answer any questions and have a chat. So I'll introduce myself and Pheonix Wills and then take you through some of the key points on estate planning. And and then at the end, like I said, I'll be guided by you guys. So I want you to get the most out of this. I am Lucy D'Ambrominal, as Kathy said. I run the Singapore business. My partner and colleague also in the picture there runs our Hong Kong business. The company's been going for many years in Hong Kong, and we set up in Singapore last year. We do multi-jurisdictional wills, and that means that we help our clients who've got assets and ties in different jurisdictions set up their wills, their guardianship, their other estate planning documents to protect their loved ones should the worst happen. We are very proudly a female-founded and full female team. And the reason that I bring that up is not to sort of man bash or be particularly feminist or anything. It's just that I believe, rightly or wrongly, that women are good listeners. I'm not going to say better listeners, but I think we're good listeners. And what we do on a practical day-to-day level, that's really important, that we're able to listen to each and every one of our clients' individual situations, because there's no one size fits all with wills and estate planning. It's very much a unique situation. But it also means that, you know, sometimes we do have sensitive and emotional situations, and sometimes we are there as a little bit of a shoulder to cry on. As Kathy said, I've got 2 children of my own, and I let you into a little bit of a secret that I actually only finalised my own document after our second was just born. And the reason that I say that is to just make the point that there's no judgment. If you haven't got yours set up and you've got questions, I would obviously urge you to do so, but don't panic. That's where we come in, or another professional will writer. So what are we going to talk about today? Common misconceptions, some sort of myth busters, top reasons for drafting a will. A lot of people say to us, well, I don't really need one. Why do I need one? So we'll go through some of those points. What exactly are multi-jurisdictional wills? Points to consider in terms of who do you need to think about in terms of your nominations in your documents, so executors, guardians, beneficiaries. The next topic will be guardians, one of the most possibly the important factor for us with young children. Other estate planning tools, it's not just wills and guardianship. There are LPAs, there are living wills, living guardianships. What do we need to do to maintain our will once we've set it up? Is it all done forever or not? And then finally, some of the reasons why a will might fail. Right. Number 1, I can only have one will. A lot of people believe that they can only have one will. And this is one of my 2 biggest points that I'd love for you to take away from today, if nothing else. So whilst you can have just one will, if you've got, let me backtrack a bit. So this is, if you have assets or ties in different jurisdictions. So I'm going to use myself as an example. I am from the UK, so I have a UK passport. I used to live in Hong Kong, so I have a bank account there still, and I live in Singapore. So I have 3 wills. So you can have one will legally to cover a global situation if you've got assets and ties in different situations, but it's not best practice. And our approach at Pheonix Wills is to do multiple wills for the different jurisdictions. So if you've only got one will, it has to go through probate, country by country, one by one. And so it would go first to your country of domicile, which is usually your country of passport. I'll go into domicile in a little bit more detail later because it can be a bit of a complicated one. So that one will would start in your country of domicile. And then once it's finished the probate process there, it would go to your country of residence. And then once it's finished there, it would go to any other countries where you've got assets. So that probate process can take 6 to 18 months per country. So you can do the maths. If you've got 3 countries, and we have lots of clients who have more countries than that at play, that could take perhaps 4.5 years for the whole process to be finalised. And if you are reliant, or someone else, I should say, is reliant on your assets, they don't get a cent until that one will has gone through probate in all of those countries. So there's a really, really long period of time until anyone has access to their inheritance. Whereas if you have multiple wills in multiple jurisdictions, they can go through probate at the same concurrently, saving a huge amount of time and money in the long run. So just to illustrate this point, and Kathy's heard this story before at our talk that we did last week, but it's my favourite. have we got the chat box open? I'm going to get you guys to have a guess on something. There was a chap who had, and this is a true story, it sounds like a fairy tale, but I promise you it's true. There was a chap that had assets and ties in 7 different jurisdictions. I want you guys to have a guess how long you think it took for his will. He had 1 will, so it would have been even worse if he'd had none, but he had 1 and 7 jurisdictions. How long you think it took for that 1 will to go through probate in all of the different countries? I need to find my chat box. Right, we've got 5 years, 7 years, 10 years, 7 years. It's 23 years, which is pretty remarkable. And after those 23 years, the really tragic thing about this is that most of the beneficiaries had passed away themselves, and most of the assets had been eaten up in legal fees. So that is why we do multiple wills for different jurisdictions. Okay, next common misconception. My parents will take my children if my spouse and I both pass away. So a lot of people think, well, I don't really need to set up a guardianship or a will because my grandparents will just take the children if my husband and I pass away. So that's not necessarily the case. Guardianship law is governed by international law, and specifically the law of the country where the children are at the point in time if the parents pass away. And in Singapore, if there aren't specifically designated an adult or adults nominated by the parents in a validly executed legal document, then the children can become wards of state. And that's because if there's any, even if there are grandparents around, there could be a debate. If there's any question mark over who is the right person to take the children, then the courts step in and they resolve the matter. All the while, the children are embroiled in this process, and we all know that the courts aren't famous for wrapping things up very quickly. So that is not something that we want our children to have to go through. So we set up guardianship arrangements within the will. We actually do them in a separate document, but I'll deal with guardianship in more detail later. But I just wanted to sort of dispel this common myth that they automatically go to the grandparents. And for anyone whose permanent guardians live outside of Singapore or live outside of the country where they're residing at that point in time, that's absolutely fine, but you should set up temporary guardians as well who live in the same country where you and your children live. But we'll deal with this in a bit. So, common misconception, I must list out all my assets in the will, and I really don't know where it all is. Quite a few clients come to us and say, oh gosh, I can't really start the process yet because I don't really know where everything is, or I'm trying to get my wife or my husband to get organized with me and I don't know where all of their stuff is. And people say, oh, I need to write down all of the bank account details because we've got to include it in the will. That is not the case. So a well-drafted will not include your assets. And that is for the reason that if you include all of your assets, every time you bought or sold something, you'd have to come back and change it, which would be an absolute nightmare, very unworkable, and get bloomin' expensive. So we draft the wills as a broad legal framework that cover your asset base as a whole at the point in time that you pass away. And then separately, you as the person who's written the will should write a list of assets. But that's homework that should be done by you concurrently with us drafting the will. And it's something that you should update ideally on a regular basis, ideally once a year. And there's no legal requirement with this. It can be in whatever format you like, but you just need to put yourself in the executor's shoes. And I'll tell you a bit more about who and what the executor is. But essentially, they're the person that sorts out your affairs in terms of your will once you've passed away. So you need to think, if I was the executor, whether it's your parents, your sibling, your good friend, they don't know all of the details of everything that I own. So you want to leave them a list so that they can look at it and go, right, okay, that's how I get into that bank account. That's where those insurance policies are. That's where the deeds are for that property that they own in whatever country. So that's really, really important to do, really important to update, and that's kept together with the will, but as a separate document. So this might sound like a bit of a mean one, but some people want to disinherit people and exclude people. And they think that you can just leave them out of the will. No, if you just leave somebody out of the will and you intended for them not to get anything, that will potentially cause issues, because they could come back, if they're a close family member, for example, they could say, well, Lucy clearly meant to include me. I'm her son, or I'm her brother. There must have been a mistake. She must have forgotten, and then they can contest it. Whereas if you truly want to exclude somebody, it's better to include them, but give them a nominal amount, $1 or something, to make it very clear and unequivocal. Not suggesting that anybody wants to disinherit anyone, but it's just quite an interesting one. This is a really interesting one. Common misconceptions: my children must be named. So a lot of people don't start writing their wills because they think, oh, well, I'm about to have another child, or maybe I'll have another one in the future, and so there's no point setting it up now. A well-drafted will and a good will writer will ask you, as personal as it is, are you planning on having any more children in the future? And if you are, then we just draft around that. We are very proud about the way that we future-proof our documents in terms of children, but in terms of getting you to name lots and lots of backups for all of the nominations, because our ideal is that actually this document lasts forever, or at least as long as possible. So if you know that you're going to have more children, or there's even a possibility, then we talk about your children as a class, as a whole, and then divide up the estate in between all of the children, if that's what you want. But if you know that you're absolutely done, then we name the children. So quite a few people come to us and say, and I'm afraid, sorry to generalize, but this is just the way that it has happened with experience. It's quite often it's husbands. They come to us and they say, I need a will, but my wife doesn't really have any assets, so she doesn't need a will. That's not the case, because assuming that that husband in this scenario, the one who has the assets, is going to pass on passing his assets to his wife in the first instance, which is very common, that people want to pass to their spouse first of all, and then once the second spouse passes, it goes to the children. But then if she passes away soon after and hasn't set up a will, then all of her assets, formerly her passed away husband's assets, are all going to go to her side of the family. Because if you don't have a will, your assets go according to the laws of intestacy of that particular country where you're domiciled. And it's not always the same order, but generally it's going to go in terms of the order of your next of kin. Storage, we'll talk about this a little bit later. Essentially, it's really important that you store your will in a very safe place, because it's still, the courts only accept the wet ink signature. So you've got the one original. Your bank safety deposit box would be one of the worst places to keep a will, because your assets get frozen upon passing away, and your bank safety deposit box would be part of that, but your will is trapped in there, and you need your will to start the probate process to unfreeze your assets. Right, so why do we need a will? Again, I get challenged quite a lot about this. Nah, I don't think I really need a will. It will just sort of go according to the laws of intestacy. Well, there's many reasons why that's not the case, but here are a few starters. It allows you to decide where your assets go. In a country like Singapore and other common law countries, you have free distribution of your assets, so you can choose where it goes. I did say, obviously, it's very common if you do have a husband or wife that people want to pass things to their spouses, but not always, and then children. But you have control, you have clarity over where things are going to go. Protecting your family. Now, this goes back to the timing point. If you don't have a will, then the process by which your estate is wrapped up is not a probate process. It's called letters of administration, but we don't need to go into that. The point is, it's much, much, much slower for everything to be wrapped up and distributed according to the laws of intestacy. So by writing a will, you speed up that process by such a huge amount that it means that people who are reliant on your finances can get access to those finances far, far quicker. Keeping the peace. Unfortunately, I'm sure, all heard of or even experienced situations where things get a bit nasty sometimes once someone's passed away. You like to think that people are going to be civil and all brought together by a grieving process, but arguments happen. And if you have written down your wishes that are legally binding, it can prevent really, really nasty arguments. Guardians. Now, this is a whole sort of subtopic within estate planning, which is one of the most important. So within our wills, we will appoint guardians. We, for belt and braces, our approach at Pheonix Wills is to also set up separate documents called deeds of appointment of guardianship, and we do them for permanent guardians and temporary guardians if applicable. I've explained why it's really important to appoint guardians, because otherwise you're potentially in the hands of the court if there's any dispute, and there's just got to be clarity. So if we go to the next, no, that was later on. We do permanent guardianship, and if our clients have family or friends outside of Singapore, and those guardians are outside of Singapore, that's absolutely fine. That's no issue at all. But we do need to appoint temporary guardians within Singapore. And we set those temporary guardianships up in the wills as well, in the Singapore will. And we also set up this extra document, deed of appointment of temporary guardianship. And the reason for that is, even if there's a permanent guardian set up in a valid document, they need to take a little bit of time to get into the country. And even if it's only a day, there's got to be somebody in charge of those children for obvious reasons. And it's got to be somebody that the parents have chosen. And there's no dispute around it. Otherwise, like I said, the alternative is unfortunately state care. And we don't want that. So temporary guardians are in Singapore. We always advise people to think of backups. And it's really important for all of the nominations. It's important for the guardians, if you can. I know some people say I would only like my mother, or I would only like my sister, for example, to be the one that's looking after my children. But we word it so that it says, if that person is unwilling or unable to take on the appointment, then it will go to the next person. So you can have an order of priority, which works well. And then for the temporary guardians, because Singapore is very transient, people go away, people leave the country. So even more important to have a set of backup temporary guardians. We suggest, in an ideal world, 2 to 3 couples or individuals plus a couple of backups. And then it just means that you don't need to think about it again, and you don't need to come back and change it. One global will versus separate wills per jurisdiction. I've touched on this really. I think it's such an important point. But to recap, you can legally have one will to cover a global situation, but it's really not going to be best for those that are left behind, primarily from a timing point of view. Much better to set up the separate wills. And ideally, those separate wills want to be set up by the same will writer, because then you can make sure that they all work together cohesively. They've got to refer to one another, and the signing order has to be in the right place, because the general rule with wills, if you've got multiple wills, is that a later will revoke an earlier one. So a later will, unless stated otherwise, unless it's properly joined up with the others and someone who knows what they're talking about, you could end up making the previously written will null and void, which we don't want. So I talked about country of domicile. If you are somebody that has international ties or assets, we need multi-jurisdictional wills to be best protected. So country of domicile, that is usually, it's about your home, your citizenship, where you belong. So a lot of people come to us, they're like, well, I'm not really sure what my country of domicile is. I've got 2 passports, and I lived here, and I was born here, and I've got ties here. So domicile can be a very simple one to decipher, but it can be a little bit more complicated. And you must be domiciled when it comes to your will. It's really important that it states where your domicile is. Part of that is to do with inheritance tax in countries where that, or estate tax in countries where that applies. But it's also, it goes beyond that. Your country of domicile is the country that dictates the laws that apply to your worldwide assets. And if you only have one will, the court, if it's presented, let's say, for example, we'll use me again. I'm domiciled in the UK and I've got a bank account in Hong Kong, but I live in Singapore. If I just had that one will in Singapore, Singapore courts would look at it and go, well, she's domiciled in the UK, I'm not looking at it. And it would be sent to the UK and it would have a whole process there. And then it would come to Singapore and then it would go to Hong Kong. But your country of domicile, it's really important to stress that it's not the same necessarily as your country of domicile while you're alive. Your country of domicile, when it comes to your will, can be different. And that's why I say it's about your home. So we go through a series of questions to ask people if they're a more complicated one in terms of domicile, but it's just one to be very aware of. Yeah, country of residence, you should have a will there. There is an assumption that you have assets there and therefore it needs to go through probate, and anywhere else where you might have assets. Executors, these are a really important nomination. Executors are the people that are initially in charge of finding your will, presenting it to the court, and then dividing up your assets amongst your beneficiaries according to your wishes. People quite often think that this needs to be a professional. It doesn't, and we would advise against it being a professional. It's better, if possible, to keep it close, personal, somebody who knows the family and knows your wishes. It's not a difficult job. It's admin heavy at the start, but essentially the most important thing, if your executors are then going to go on to be the trustees of any minor beneficiaries, which I'll go on to in a minute, the most important thing is that you just trust this person or these people implicitly. If you have minor beneficiaries, so if you've got young children, 18 or 21, depending on the country, their inheritance will go in trust, and we set that trust up as part of the will. And it's essentially a bank account in their name, but that is managed by the trustees. In a lot of countries, you have to have 2 trustees if you have minor beneficiaries. In other countries, it's recommended. Commonly, people's executors, once they've done their executor job, they will then in turn become the trustees, and that makes a lot of sense for continuity. Some people very occasionally, for certain reasons, want to pick somebody different. But the important thing to remember, if you have minor beneficiaries, and we're all part of Pregnant and Pop, so I'm assuming that we all do or will do in the future, you need to have 2 trustees. And these people, again, don't need any sort of specific unique knowledge. You need to just be able to trust them implicitly to look after the assets on behalf of your children. And then you can choose the age that you'd like your children to access that inheritance, and you can choose an age between 21 and 30. Some people go right down to the bottom, some people go right up to the top. And interestingly, it seems to depend on whether people have girls or boys. I think people believe that the stereotype there it is that boys are perhaps a little bit more irresponsible with money. But no, a lot of people pick an age somewhere in the middle where they know that children will be out of university and maybe a little bit more responsible, but it's entirely a personal choice. Beneficiaries in different scenarios. Beneficiaries are just the people that you are giving your estate or your assets to. It's very common to go to spouse, then children, but not necessarily. And obviously not everybody has spouse or children, so it can go to whoever you want. What we do advise strongly to people is that they name backup beneficiaries. Like I said, we're all about backups. We don't want you to have to come back and change this, but if God forbid there were to be an accident or a scenario where children predeceased the parents, we want to have backup beneficiaries so that at least you can have comfort that the assets are going somewhere and not going to the government or to the state. If our clients are couples, our practice is to do mirror wills. That means that they're broadly the same. They sit alongside each other, but you have a separate will per person, and that works where people want to do the same things as each other. They want to name the same executors, the same beneficiaries, and the same guardians. If they want to do different things, that's fine, and we do individual wills, but it's just a slightly different price. Joint wills are a thing of the past. We don't do those, and in fact, in some countries, they're not even legal anymore. That harked from ancient times where women didn't really have assets of their own, and indeed they were almost like property themselves. So it doesn't really work now, and if anyone were to want to remarry, for example, after their former spouse had passed away, then a joint will would cause enormous issues, so we don't do those. Guardians for your children, I think we've done this really. It's just such a key point. We put them in the wills, we back them up in the other document. I was speaking to somebody the other day who's got a will but decided not to put guardians in for their children, which was absolutely mad. It's literally the number one important thing in my opinion. So I've talked about permanent guardians. These are the ones that step in instead of the parents. They act in loco parentis. And this is the number one thing that takes our clients time to give us their instructions. As you can imagine, this is a big conversation between parents, particularly if parents have got families in different countries. Perhaps obvious, but a lot of people don't realize this. You really must ask your guardians before you name them. If you go with us, we will ask you to hand them a document, their copy of their guardianship form, so they would find out then. But this is an enormous job, so please do ask them beforehand. Temporary guardians are the ones that plug the gap until the permanent guardians can come into the country. Living guardians and medical proxy. This is, so the permanent guardianship and the temporary guardianship, they only kick in if both parents pass away. But the living guardianship is another estate planning tool that we would always recommend to people if they go away without their children, you know, if they're a nice weekend away or work trips or whatever, because that allows you to appoint somebody or some people to step in and look after the children if the parents are either incapacitated or uncontactable. And it also allows you to appoint a medical proxy. So if anything happened to a child and they needed to be taken to hospital, there are some procedures that hospitals can't perform without parental or appointed guardian permission. So just to give you an example, my colleague who runs our Hong Kong business, she was doing a talk, ironically, on guardianship and didn't have her phone with her. Her husband is a pilot, so he was flying, and she looked at her phone afterwards and had hundreds of missed calls from her child's school and the hospital. And essentially her child, he's okay, but essentially her child had fallen over, slashed his eyebrow, and the hospital weren't able to do the procedure that they needed parental or guardian permission for. They just had to do what they could to sort of stop the blood flow and anything else like that. So it's a useful document. It was a very popular document to set up when Hong Kong went a little bit mad during COVID and parents and children were being separated. So it covers a situation ranging from anything to a parent is in a coma or uncontactable. A lot of people ask whether they're able to name their helper as a guardian. Unfortunately not. Our helper's existence here is tied to our existence in terms of their visa. So if parents, their employers pass away, then they have technically no right to work here and they've got 30 days to leave the country. So what we do in our documents, we include some wording if clients want it. We include some wording that allows the helper to stay with the children until the permanent guardians can come in and take up their role. It's not legally binding because of what I've just explained, but it's persuasive. Unmarried parents, it's very wise with guardianship to nominate each other as the first guardian because of the situation in Singapore, perhaps a more conservative country on that front. It's just sensible for belt and braces just in case it's not recognised. Right. Hopefully you're all still with me. I've got no idea because I can't see anyone. Can you give me a thumbs up to show me you're not asleep and everyone's there? And also I want to give you some comfort that you'll stop hearing my voice relatively soon. We've got a few more slides to go. Other estate planning tools, it's not just wills and guardianship. Living will or advanced medical directive. Now, this is a document that you can set up to say how you would like to be treated or not in certain situations, in certain medical conditions. Lasting power of attorney. This is another one, like the living will on the previous slide. This is another one that kicks in when you are still alive but incapacitated. The will only kicks in once you pass away. So this one allows you to appoint somebody or some people, a donee, to essentially manage your financial affairs if you are not able to. There's a very slick system set up online, set up by the Officer of the Public Guardian. It's relatively new. And if the people that you're going to appoint as your donee, your attorney, are in Singapore and have SingPass, then you just do the whole thing online. There is a cost, but if you are a Singapore citizen, the cost is free at the moment. They're waiving it for the next year or two, I believe. And then there's a reduced stepping in price depending on your status. So Singapore citizens, it's free for the moment. PRs, there's a charge, and then if you're a foreigner, there's a higher charge. Anyway, I'm very happy to guide anyone through that, but it's a very slick system online. Insurance, obvious overlap. It's not something that we do, but really important to either check that you've got some in place or look into it if you haven't. Life insurance is a really helpful tool to protect those that are left behind. Also, life insurance pays out upon receipt of a death certificate. It doesn't get sort of trapped and caught up in the probate process. I was talking before, there's always going to be a little bit of a delay until anyone can access any funds after somebody passes away, but life insurance helps to plug that gap. My main advice would be to make sure that you speak to somebody who really knows what they're talking about, particularly if you've got ties overseas, because it can sometimes need to be set up in a certain way, and make sure that they don't try and get you to take out more than you actually need. Maintaining your will. So what happens once you've set it up? Really, really important to keep it safe. In an ideal world, it will be kept in a fireproof and waterproof safe. We do have a storage facility, and most will writers will do as well. As part of that, we get in touch with the executors on an annual basis to let them know that it's there, remind them of their jobs and their duties. Really important to keep it out of reach of any scribbles. We do ours on nice sort of bubbly textured paper, and my colleague's children was found scribbling on the paper. So it's quite nice for children. So really important to be kept out of reach, and that there's no, because if you annotate a will, it could look like someone meant to change it, and then it could be called into question about its validity. We offer an annual review service, which if you've put all of the backups in like we've advised, you may not need that, but if people feel like they've got lots of situations that are going to be changing in the future, then that might be something of interest. If changes do need to be made, like I said, our advice is to put lots and lots of backups in so that you don't need to change it, and we try and future-proof them as much as possible, but sometimes changes do need to be made. For example, if you change your mind about one of your nominations, then we can change them very easily. Right, this is nearly the final one. Reasons a will can fail. Incorrect or missing date, perhaps obviously. Unsuitable witnesses. A witness cannot be a beneficiary in a will, and then they've got to be over 21. The signature needs to be recognisable and correct. Otherwise, the court's going to call you in to test your signature. If there are any damage or alterations, so I mentioned children scribbling on wills, any alterations that aren't done properly could be seen to be an attempted change to it. They could also revoke a will. If there's any damage, even as far as putting a paperclip, for example, on the top of the will, which then leaves a mark, it could look like there was previously supposed to be an extra document there attached to it, which has gone missing. So that could call it all into question. So it's really important that it's kept carefully and safely. I touched on this before. If there's no surviving beneficiaries, that's why it's really important to put backups in, because then who's it going to go to? Potentially, worst case scenario, the state, the government. Marriage or divorce. Please know, if you don't already, that if you get married after you've set up a will, that marriage will revoke the previous will, so it'll be null and void. The same with a divorce. If you divorce somebody, the will views that ex as no longer around. But that's not the case when you're going through a separation. During the separation period, it's really important to set up or update wills, because they will still be seen to be the husband or the wife until the divorce is actually finalized. So that could end really badly. And then finally, the number one reason that a will fails is because nobody can find it. And this is why we do our backup guardianship documents. People put their wills in really safe places and they forget to tell anybody, or then they move it and forget to tell anybody where the new hiding place is. And yeah, very easily avoidable. Thank you for listening. Sorry if I've talked for quite a long time. Hopefully that's helpful. Here are our contact details. We have a QR code here for the website. You want to go on there, and you're very welcome to book a free consultation. If you found today useful, do scan the code and give a Google review. You've no idea how much that helps a small business. Give us a follow on Instagram, Pheonix Wills Ltd. And like I said, get in touch with any questions or ask any questions now. Thank you, everyone.
Hey, Lucy. Wow. I've heard you talk a little bit about this stuff before, as you'll know, but every time I hear you know, there's something, it refreshes me. It reminds me how important it is that I actually go and find mine. I am one of the people that has one, I think, in a drawer somewhere, but I've moved 3 times since then. And I'm not entirely sure which drawer it is in now. So mental note when I get off this call to go and find it. I also fall in the camp of I probably should have the multi-jurisdictional. I currently have one. I was poorly advised that was, you know, going to be okay. And I've obviously since learnt that it's not. So I need to really, really get cracking with that. And you're right with the conversation about guardians. You know, it is important. That is a serious conversation to have. We had that conversation with the people that we wanted to appoint. And actually we did, I think we did speak to one person or a family, and they were like, actually, no, like, not in a nasty way at all. But they were like, it's, you know, it's just not something they obviously were good friends, you know, and they would have really stepped in if ever we needed them to. But essentially they were like, if there's someone better out there, then please go with that. So it is important to have that conversation.
I think that's a really good point to make. I've had 2 personally quite interesting conversations with people. There was one really, really good friend, couples, that we asked to step in as our kind of third in line after parents and siblings. And they said, can you give us a few days to think about it? And I was like, yes, of course, that's great. They're taking it seriously, and did come back and say yes, which was nice. And then on the flip side of that, one of my best friends handed me a permanent guardianship form. Luckily, I'm happy to take on that responsibility, but she'd forgotten to ask me. And their son is my godson, and I'm very happy to, and you know, I'm sure it's not going to need to come into play, but I laugh about it, and it has turned out to be okay in our situation, and she was mortified. But yeah, really, really important not to forget to ask these people.
Yeah. And also the fact that you make sure that you ask for multiple temporary guardianships for expats living abroad, because we are so transient, and the people that we, you know, might appoint are so transient and moving around. I'm actually thinking about who's on my form at the moment, and yep, that needs to be updated. Like, my number one no longer lives in Singapore, so I really need to look at updating that. So yeah, it's you always remind me of things that I need to get done. I'm going to give people the opportunity to ask them more questions on the chat, although if you should be able to unmute yourselves. It should be set if you want to unmute yourselves and ask any questions, or even, you know, come online and ask us if there's anything in particular that Lucy can cover from a general perspective. We do appreciate, we do. When we make a will, there needs to be 2 witnesses. That's a question. Are they required to read through the whole will, including the list of wealth and assets? That's a good question.
Really good question. A few questions in there. Thank you for that. So yes, correct. There do need to be 2 witnesses. And when we go through the process, we get people to come to our offices, and we provide the witnesses. So the witnesses as long as they are not a beneficiary of the will, and as long as they are not under duress, and as long as they're over 21, it can be anyone. So we deal with the witness side of things. So yes, we will have read through the whole will, but if for any reason you are signing your own will, very occasionally people can't make it in and we do the will over video, and you'll find your own witnesses, which is fine. It's not ideal because people do make mistakes and then we have to redo it. But if you do find your own witnesses, then no, they are not required to read through the whole will. And actually, we wouldn't recommend that anyone else reads your will. It's a very personal document, and it's a very strange one to read while you're still alive for someone else. And it's actually nobody's business until you've passed away. And the same applies for the list of assets. All very personal. And I would go so far to say that, and totally understandably, this is such a personal thing to have all of your assets, and to do your list of assets in the most thorough way, you'll include passwords as well. So obviously that needs to be thought about, how you want to encrypt that in the way that suits you best. We don't even need that. And all we need to know to draft wills are which countries you have assets in, and who you want to nominate, obviously, for the executors, beneficiaries and guardians. But in terms of your assets, where they are, and whether it's real estate or not. So contents of your will, highly personal, and the list of assets.
Okay, but interesting. So you say in emergencies, you sometimes do this over Zoom and stuff as well, do you, in absolute emergencies?
Yeah, well, not necessarily emergency. It's really not our preference, because with the wills, it sounds a bit mad because you're just signing, but you have to sign every page, and every witness has to sign every page. The witness has to also date their signature, perhaps, obviously, but the few times that we have allowed this to happen, it goes wrong. And quite often people will sign on a different date from the witness's signature, which doesn't work, because that would suggest the witness hasn't actually witnessed the signature, which is the entire point of having a witness. So it is possible if people really can't make it in. And if we do have to do that, then yeah, open video would be better, so we can see what's happening. But yeah, sometimes people are in different countries, and that's the way that we need to conduct it.
Okay. And how do people deal with you mostly? Do they come to the office? Do you start off on Zoom?
Good question. Really, it's down to the individual. So we always offer a free consultation to start out, which allows people to ask questions. We find out a little bit more about the situation, and we can give an initial quote. That's usually done over Zoom, but if someone really wants to do that in person, that's absolutely fine as well. But in this day and age, we find that most people prefer Zoom because everyone's so busy. And then if people want to go ahead, then we need instructions, and instructions are some details about you, who you want to nominate as your guardians, executors, beneficiaries, final wishes, a few other things that I haven't mentioned. I mean, if you've got pets, we want to know who your pet guardian is going to be. So we have a questionnaire. Most people choose the questionnaire because they like to fill that out in their own time, and it acts as a nice prompt, and they can sit there with their partner if they have one and go through it together. And then you submit that, and we do the drafting. Other people prefer to give their instructions over Zoom. Some people prefer to do it in person. You can come to our office, which is near Raffles Place. So entirely how you want to conduct it. And then once we've got the instructions, we do the drafting, send you the first draft, and then once you're happy with that first draft, we go across to the other documents, we mirror them. And then once you're happy with the final one, and you've asked any questions that you might have, then we arrange for the signing.
Hey, like you say, I bet it is quite a powerful conversation to have. If you're sitting at home going through that questionnaire, it must be at times for, the partners quite empowering to sit there and have a reason to discuss these things without it being, presented from one side to the other, as it were.
Totally. And the questionnaire can act as a bit of a sort of a mediator.
Yeah, I can really see that. We do have one last question, because we have run over just oh no, we've got a couple of minutes to go. So we've got one last question. Can the executor also be on the list of guardians?
Good question. Yes. Yes, the executor can also be a guardian. Some people really want it to be the same person that is involved with the whole process. The only thing to be aware of with that is if, God forbid, the guardians did need to come in and take on their role as guardian, that's obviously a big job. They're dealing with minor children who've just lost their parents. You don't really want them to be distracted by their job as executor, which, as I said, is not rocket science, but it is time consuming to start with. You know, they've got to physically present the will to the court, and then there's the finding the assets and the paperwork. So yes, they can, but might be an idea to think of alternatives if possible.
Okay, that makes sense. I mean, just thinking logically, does it make sense though, if you do have young children, that the executors and the guardians maybe know each other? I mean, I'm just thinking because a lot of what is going on maybe would have the impact on the children, you know, further down the line. I mean, do you notice that things go a little bit smoother when they know each other?
Yeah, absolutely. And I think that's a really good point. Yes, that would be ideal, but again, it's not essential. The other thing to think about with executors and guardians is executors, it can be a good idea to, if you've got minor beneficiaries, you need 2 executors plus some backups. So it's an idea to think about somebody on each side of the family, if you can, and not everyone can, but so you've got one side representing each side. And then on guardians, a lot of people say, well, should it be one person or should it be a couple? Another thing to bear in mind when thinking about your guardians, as well as where they are and who they are and what their living setup is you can write a letter of wishes, which is a non-binding document that you would keep together with your will, with your list of assets as well as a separate document. And you can write in there anything that you want. A lot of people use it for how they would like their children to be brought up, what type of schooling they'd like them to have, what country they'd like them to live in, you know, down to what table manners you'd like them to have. And some people do it in the form of a video as well, which can be incredibly powerful. So that's another thing to think about. It sort of adds amazingly powerful context to your wishes, but that kind of level of detail you wouldn't put in a will.
And that makes me almost emotional.
Yeah,
like it's like a letter too, like a future letter too.
Exactly.
Oh, wow.
Exactly. The final thing I wanted to say on guardians as well is, and the advice is different with permanent guardians and temporary guardians. A lot of people will pick for their permanent guardians, parents perhaps, but for obvious reasons, we'd want backups for parents, but siblings. And if it's your sister that you're super close with, but it's worth thinking about just naming your family member or your close friend rather than a couple, because if you name them jointly and they part ways, or I don't know, something turns ugly, I know it sounds really negative, but we just have to think of all eventualities. It's better to have just that family member, because otherwise, if they're named in the legal document, joint legal guardian, they will have equal rights even once they've split, if that happens. Whereas with the temporary guardians, the advice is slightly different. They're only going to be in play for a matter of days, probably maximum. Better to put, if you trust both of them, both sides of a couple, if that's who you want to pick, because it just means you've got an additional layer of belt and braces. If one of them's away, then the other one can step in.
Wow. That's like really subtle but amazing extra information to think about.
Well, hopefully helpful, and hopefully hasn't scared anybody.
Well, we've had a record number of people sign up at the start. I think some people kind of were, it's lunch hours. So we've had some people kind of come on and maybe drop off at a little point and then come back on and vice versa. But we've had pretty much everyone that signed up. has managed to drop in at some point on this call. So it's obviously been a really, really important subject for everyone, Lucy. And like I say, the recording will go out to everyone. I will edit this down so that you can digest it at home, and possibly most importantly, sit down with your partners and maybe use this as a prompt to be like, look what I learnt. And then you can start that conversation going in your own household if you haven't started it already. How does that sound, Lucy?
That sounds great. Thank you, Kathy. And thank you everybody for sparing your precious time.
Well, it's been an absolute pleasure hosting you, and I hope everybody goes about having a wonderful day. And don't forget, you can get in contact with Lucy anytime, and you can always get in contact with me if you need to. Thanks, everyone. Have a great day.
Bye, everyone. Bye.